Chief Justice Gertrude Torkornoo is once again fighting processes to remove her, this time not just in the court, but before the cameras too, outlining 4 key reasons for breaking her silence this novel way.
Every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy.
Her message was strong and direct. She will not resign, describing the proceedings to remove her from office as unconstitutional, unlawful, and dangerous for Ghana's democracy.
If I resign under these circumstances, I will be saying that this flawed, unknown, and opaque process is acceptable. It is not.
This is the first time in Ghana's history that a sitting Chief Justice faces removal through such a process. Justice Torkornoo called it historic but deeply flawed and warned of the lasting damage it could cause to judicial independence.
It's historic. In all of Ghana's 68-year history as an independent republic, there has never been a hearing for the removal of the Chief Justice. One would therefore have hoped that if such a process becomes necessary, it would provide good guidance and precedent for nation building. Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country.
The suspended Chief Justice says the choice of Edu Lodge, cordoned off and heavily guarded, is psychological intimidation.
I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge.
She also challenged the 3 petitions that triggered her suspension, calling them misleading, misinformed, and in some cases, outright false.
And so I knew that it was necessary that the issues being thrown around as petitions against me needed to get into the public space. I swore to a supplementary affidavit alerting the Supreme Court also of human rights violations that I had started encountering when I went to the Article 146 hearings. However, the members of the Supreme Court that had the application for the hearing in open, and they also struck out the supplementary affidavit at the request of the Attorney General. I have decided to make this statement today because the violations have not stopped. Indeed, they have escalated beyond anything I could have imagined as possible in justice delivery.
In the last hour, the embattled Chief Justice has taken legal action at the High Court, hoping to challenge the legality of the proceedings and to stop what she describes as a miscarriage of justice.
It is this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file applications for judicial review in the High Court to declare all the proceedings void. Because the clear danger is that through this flagrant violation of CI 47, and the darkness of the current proceedings being held in camera behind the walls of Edu Lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue.
Justice Gertrude Torkornoo insists that she's innocent in the face of all the allegations that have been made against her. She insists that staying to fight is not a battle for her alone, but if she wins for the entire judicial system. For Joy News, Michael Ashale.
So welcome back to the AM show, to our big stories today, and we're focusing on the Chief Justice's presser yesterday, in which she made a lot of revelations about this particular case that is ongoing. She says that the inquisitorial nature of that particular, process has now been turned into a normal litigation process in the court of law. We want to delve into these matters and to find out where lies the real fact that we all need to understand about this particular case. Myself and Sweetie will be doing this together. And joining us is John Darko. He is member of Parliament for Swami and legal counsel for the MPP. I'm grateful to you, sir, for joining us here. We also have Dr. John Osai Kwapong. He is a CDD fellow. Doc is joining us via Zoom. I'm grateful to you, Doc, for joining. Let's start with you, Dr. John Osai Kwapong. First, your thoughts on the CJ's presser yesterday.
You and Sweetie. I think for me, my initial reaction was one of a bit of surprise. Surprise in the sense that the nature of the proceedings is such that I wasn't expecting a full-blown presser that delves into the process, the issues at stake, etc., etc. But the Chief Justice feels compelled to bring her case directly to the public, and so I can't fault her for that. Except that I think, for me, it also raises some concerns about how we treat institutions, institutional processes, and whether sometimes some of these actions have unintended consequences of delegitimizing processes that are enshrined and spelled out in the Constitution.
Now, again, as we played in that report, she says she wants to fight this to the last end because she feels that if she allows this to go through, it could be done to any other CJ in the future. I mean, do you get the effort that she's putting into this fight from that angle? That being the CJ, she wants to make sure she protects the judiciary from these, as she put it, the agenda to make sure that they push the CJ out.
There are legitimate concerns about the design of Article 146, and particularly 1466, which deals with how you remove the Chief Justice. I have had occasion to write about it because I think we really need to go back, and there's a constitutional review process going on, but we really need to go back and, in my opinion, fix some of what I consider to be the fault lines in 1466, right? For example, I think it's a little too vague when it says that the Chief Justice can be removed from stated misbehavior, incompetence. The third part, unable to perform their duty, their job due to certain things, right? So, God forbid, but if a Chief Justice were, to lose their faculties, if they were to, pass away, it's obvious that you can replace. But what do we mean by stated misbehavior? What is incompetence? And my concern has always been that we need to flesh it out a little bit more so that if you are going to apply the highest form of sanction against the Chief Justice, which is removal from office, you leave no doubts in the minds of your citizens that he or she must have done something very egregious. So in principle, I can understand why, she and others would want to draw attention to the nature of how you deal with the removal of the Chief Justice from office. My biggest concern is that those who keep saying all of this is unconstitutional, in my opinion, have not pointed out exactly what the constitutional infractions are, right from the beginning up until this point. What is it that has been done that offends the Constitution, right? The Constitution makes it very clear that this is a process that has to be held in camera, essentially a private process. I don't like that. I don't like that because for me, again, if you're going to remove a chief justice from office, at least a bit of, transparency so citizens are not left to second guessing the motives of institutions is important. But we have to live with the constitutional prescription of what is. We can't use what ought to be as the standard or the measure against which we make assertions that something unconstitutional is being done. And that, again, for me, is my worry, even when I agree that in principle, there is some legitimacy to the concerns that we ought to be very careful how we treat the heads of independent constitutional bodies.
Let's bring in now John Darko. He's Member of Parliament for Swami and Legal Counsel for the NPP. And sir, thank you for your time. The Chief Justice, the suspended Chief Justice, fights on. According to her, despite what she calls the draconian approach in which the Gabriel Poman Committee is conducting this inquiry, she's willing to marshal through and prove how frivolous the allegations are against her. Dr. John Osai Kwapon has raised a pertinent question, which I want to throw to you. Where is the constitutional infraction? Because she says this is unconstitutional. First, feel free to reflect on how or what you thought about the entire presser, but tell us exactly where the infractions are, for which reason we are calling these the process unconstitutional.
Thank you very much, and good morning to your listeners. So, I think, first of all, you need to look at the fact that the constitutional right of fair hearing is enshrined in our Constitution. Fair hearing demands that at any point in time, a person should be given ample time to respond to issues that are brought against the person, and then the person should have the opportunity to also respond to it. One of the issues I believe the CJ raised is even the finding of a prima facie case against her, that when the committee said they had found a prima facie case against her, she wanted to know, what exactly have you found? What are the issues? These issues were not made known to her as which particular area, okay, that they found that there's a prima facie case against her. Those ones were not provided for her. Clearly, it violates the right to fair hearing within the constitutional provision. And so, for me, I think that the CJ is right. If you look at the removal processes, yes, it is there, just like Dr. Kopon said, it is there, but it doesn't trample the other rights that she has as a citizen first, and of course, as a CJ of the Republic. And so she needs to know exactly what the prima facie case was. She requested for this, she didn't get it, she went to the Supreme Court and they didn't listen to her. So those are legitimate issues that she's been raising.
It sounds like, Kojo, just a second.
Yeah.
Mr. Darko, it sounds like the Chief Justice, the suspended Chief Justice, has no faith in the judicial system, and she's fighting to head the same system. That's what it sounds like, that she's lost all faith in the processes of the judicial system, which is hearing her case now.
No, I mean, you can see that she went to the Supreme Court with some applications, they've been dismissed. But because she still has faith in the judicial system, that is why she filed this question at the High Court to bring the proceedings before the committee, before that High Court, for it to be quashed. So if she didn't believe in the judicial processes, she would not be filing these applications. She believes in it. But look, let us not forget the political undertone. of this whole process. That from day one, the president, when he was campaigning, said that he was going to make sure that she should move. The chairman of the NDC has said in so many occasions that she needed to go. And so she's a human being, and she understands the judicial process, but she also understands that there's huge political undertone to all of this. Everything being done is being done because of politics. Because for politics, these allegations will not even rise to the level it is right now. And so, yes, my dear, you may think that she doesn't have faith, but I believe she has. She has faith, that is why she still goes to court. But she also understands that the political undertone of this case, that this case is just a political persecution to get her out of the office simplicity.
Is that, right before Kojo comes in, is that justification for that presser we saw? Because ordinarily, she shouldn't be addressed in the public. We shouldn't be hearing her case in public, but she took it to the public.
Well, you see, it is very important. And I believe that there were a lot of things that you didn't know that now you know. The government spokespersons had littered the media with all kinds of allegations. They've been putting some of these allegations out there. And because you are not seeing a rebuttal at a committee level, I believe that it was important that she made the people of Ghana understand that, look, all the lies we've been hearing, all the stories we've been hearing, these are the real hard facts. These are the truth behind all the things we've heard. So I believe that it is the right thing to do. The people of Ghana, look, all of us, we serve at the interest of the people of Ghana. And so in situations like this, you need to let the people who you serve know and understand. And I don't think she's breached any provisions in the Constitution. The constitutional provision that the hearing should be held in camera is being adhered to. It's being held in camera. Even though she challenged it, even though she feels that this should have been done in the open, it is still being done in camera. But she needs the people of Ghana to understand her story. She needs the people of Ghana to also hear her side of the story, because the government communication has always been putting out light against her.
But I mean, she's a Chief Justice, and at least she must be aware that the same Supreme Court has in some cases affirmed that Article 146 proceedings must be held in camera. So why was she pushing, or why is she still pushing that this same process, because of openness and accountability, must be open to the public?
Well, I mean, I think that you yourself, you agree with me that this is unprecedented. Okay? This is so unprecedented. We've never had the head of an arm of government be removed before in this country. And so it is imperative that the people of Ghana are carried along to know exactly what is happening. So yes, she understands that one person is supposed to be held in camera. The ones that have been held in camera were not heads of these arms of government. So this is so peculiar, this is so different, and I believe that she was right in asking them to as it were, publicize it. Do you think, as a media person, don't you think that if this thing was being beamed live on TV, you would have helped all of us? Because right now,
even when the Constitution does not permit it.
So I'm saying that constitutional provision is there, but she is saying that she believes that her story has to come out there because the government spokesperson have already put out light about her. You have heard out of these petitions. How did you hear them? Because the government spokesperson put them out there. So it is important that for her as an individual whose reputation is being dragged in the mud to come out to explain to the people that, look, this is the issue. And it doesn't violate that provision of in camera at all, because the committee's hearing is being held in camera. But she needs to explain to the people of Ghana what she's going through. For instance, is it fair that the Chief Justice will be subject to the kind of steps she told us about when the Chief Justice is going before a commission of this nature? How do you subject her to such kind of statutes? If she doesn't tell the people of Ghana, how do we know how her rights are being violated? If she didn't tell us, were we going to know that her lawyers are not even being job organized? That right that you must have a right to counsel, okay, is enshrined in the Constitution, and everybody is entitled to it. Why is the Chief Justice being denied the right to be heard by a counsel of her own choice? If she didn't come out, were we going to know? So for me, the need for us to know this, okay, trumps every constitutional provision you can even quote to me. If her human rights are so important that it might be, just like any of us, all of us are human rights, provisions are so important. We cannot use these constitutional provisions, okay, to push away her human rights.
Let's bring in Dr. Kwapong again. Doc, so, I mean, the CJ makes a point about the fact that the petitioners are not being allowed to testify on oath, and she has an issue with it. Looking at the unprecedented nature of this particular process, do you think it is something that the committee should allow these petitioners to adduce evidence for the petitions that or the allegations they level against the CJ?
You know, some of these proceedings are also guided by various rules of procedure. So if there is no obligation, right, per the rules that a petitioner should, appear before the committee and give evidence in person and, explain why they brought a particular petition before, that committee, then yes, it is concerning. But if there's no compulsion by law to do that, I don't see why they should. Yes, for me, it would be good that if I am going to bring a petition, asking for the removal of the Chief Justice, that I would want to make an in-person appearance and explain why, or, even subject myself to further questioning, etc., etc. But at the same time that we want to talk about, the rules of procedure and the rules and the laws that govern the way things are done, are designed to be carried out, we would have to apply those same principles and recognize the fact that the petitioners also, as per the rules, do not have any obligation to show up. Yes, it would be nice if they did, but if the rules doesn't say they should, then that's what we have to live with. For me, again, this just at least gives us an opportunity to really look at this entire 146, 1466 process, and where we can, fix, in my opinion, where some of the fault lines are. But what we have is what we have, and that is what we will have to go with, for now, even in as much as we would disagree with the design or how the process has been established. That is what we've been handed, and that is what the court has also reaffirmed in 3 different cases, that this is how this process should unfold.
In recognition of the processes, you just said recognition of the rules, because the rules are the rules. And to quote the Chief Justice's famous, the law is the law. One of the most topical things, the fallout from that presser yesterday, is the use of what she calls an intimidating venue. Case in point, the Edu Lodge. Help me understand what exactly we do with this information coming to light, how it gives her some sort of emotional torture just driving by, how she's being tried behind these high walls, and it's the same place that her uncle was persecuted, to sum it up nicely. Should we acquiesce to her demand that that place is causing her emotional torture, and therefore, because she's the Chief Justice, make an exception for her? Whereas we know that ordinarily, the hearing is supposed to be, happening in the conference of the Chief Justice and not somewhere outside. Help us make sense of what's coming in from her side and the response from Phyllis Kwachufo yesterday, Dr. Jonas Kwapong.
So I'm not one who likes to read sinister motives into the things people do. The caliber of the committee, the persons of the committee, right? You have 2 former Supreme Court justices. You have someone in the person of Domevlu, right? I would want to believe that these are not persons who will sit down and conspire to pick a venue.
Oh, we lost.
justice and
Okay.
and break her down, right? I don't believe these are the caliber of persons who would conspire to intentionally do something. Having said that, I'm also a human being. And if the venue causes this kind of trauma, I believe that the persons on the committee are conscientious enough that, who knows, you can request a change of venue based on these circumstances that most of us didn't know that you've shared, to say that, hey, this place that you are bringing me is causing X, Y, and Z. Is it possible to change the venue and see what happens? But it is hard for me to believe that the likes of the Movlo would sit down and say, we are picking this particular place because of what we know it can psychologically and emotionally do to the chief justice. I even wonder how many of them knew the story that she shared with the general public yesterday.
Interesting. But Doctor, for you, I mean, if you look at her statement and the fact that this process is still ongoing, she's also going to the High Court. What's your expectation of how or what impact this will have on the process itself?
I think for the High Court process is to help address some of the human rights due process violations that she believes she is experiencing as part of this process. I'm not sure the impact that it would have on the process in terms of stopping it from proceeding. I believe that the process will still continue. How it continues, I'm sure some of these legal processes may either, like slow it down or whatever it is. But ultimately, I think the process would continue till the very end. Not until, let's say the Supreme Court were to really go back and reinterpret 1466 and sort of give it a different meaning. I don't see this not getting to its conclusion for the committee to then decide on, the prima facie case to say, yes, there's something untoward that has happened and therefore the sanction must apply, or that, after looking beyond the prima facie case, there's really nothing there in the end of story. But I think it would conclude, it would go to the very end.
Okay. But what about its impact on the public? Those of us who don't know what's happening, but we are watching all of this process on television and what she said.
Yesterday, as I was watching it on the Joy News YouTube channel, one of the most instructive comments I read from one of the viewers was that if the Chief Justice has concerns about the fairness of the system, then how much more me, an ordinary individual? And for me, that is always the thing that I have in mind when voices begin to call out institutions, sometimes in ways that unintentionally has the consequences of delegitimizing them. And so for the public, that is for me, that is my worry, that at the end of the day, it can cause that division among the public that says, well, maybe this is not a right process. Maybe this is a wrong process. Maybe, I can't even trust my institutions. We are already at a place where trust in our key institutions are really low. It's very low. So that, for me, is something that the public has to keep in mind. And the way you ensure that the public doesn't continue to lose faith and trust in the system is if we make sure that whatever things we are putting out into the public domain are generally what it is. So if you are going to assert that something unconstitutional is being done, for me, you ought to have, you need to point out the specific unconstitutional things, right? Because otherwise you leave the public, or at least some sections of the public, thinking something is not right. And when you leave the public with the impression that somebody is violating the Constitution, all you end up doing is people continuing to lose faith and trust in the institutions designed to make our democracy work.
Doug, so does her fight, I mean, some have said it's admirable that she's choosing to stay on and fight this to the very last. She herself has said that if she doesn't fight, it will mean that she's agreeing that this flawed system or process is correct. How would you assess or, rationalize the fact that she's deciding to stay on and fight to the very last end? Does that in any way inspire confidence in the system?
She has every right to fight and fight to the very end. How you fight is because sometimes inadvertently in fighting, you may even unintentionally weaken the very thing that you're fighting for and fighting against. That for me is my only caution. So yes, I admire the fact that she has a fighting spirit and wants to fight till the very end. But sometimes in fighting, you don't want what we call a Pyrrhic victory, which is you may win, but what is the cost of that winning? And that, for me, should continue to guide us.
Okay. Grateful to you, Dr. John Osai-Kwapong. We'll let you off now. Let's bring in John Darko, who is still with us here. John, one of the things that she says, and I want to quote from her statement, says that in this case, the committee has not only permitted the two of the petitioners, Mr. Daniel Ofori and a group calling itself Shining Stars, are not to testify and confirm on oath the petitions they have brought against me, but they also would not call anyone to testify on their behalf. So as we speak, there is nothing before the committee confirming the petitions brought by these two petitioners. There's also no evidence given by them on oath to the committee. But I read somewhere that, as they say in court, parties do not put their pleadings in evidence in order for a trial to be validly conducted based on the pleadings. So what's the point of what the CJ was bringing up? Do you still have John Darko on the line? Okay.
I don't think we have John Darko on the line.
Great. So I wanted to get your point that
I heard everything.
Good. So let's have the response.
Yes, so I'm saying that, look, the CJ, like she said, is entitled to have these people appear before the committee for them to be cross-examined. Because you see, in the Constitution, she, as a citizen, just like any citizen, is entitled to have her accusers appear before her and cross-examine them on the issues they have provided, the issues they have sent to the committee. It is not enough to just write these allegations without any proof there. And so, if this case is going to continue at the commission, then the people must appear. They should back up all the allegations with evidence. Okay? But for me,
but lawyer, you do also know that someone can decide to abstain from appearing before the court, not so?
Yes, that's what I was coming to. That in the absence of any evidence and the fact that they refuse to appear, these two, the combination of their absence and evidence, should make it easy for the committee to dismiss the petition.
Okay.
You understand? Because when you make an allegation, for instance, that she did not retire an imprest, okay, you have to back it up because it's just a mere accusation. Now she has evidence that, yes, I received this money, but I retired the imprest 2 days after I came. It makes the case of the petitioner very weak in my view. And so, even though she's making a point out of it, I am happy that the people have chosen not to come because they probably cannot back up their claim. I'm happy that they haven't given the evidence because obviously they don't have any evidence of the claim they have made. And all these things will inure to her benefit in my view.
Okay.
Mr. Darko, let me piggyback from what you just said, that you can't make allegations without proof. Yesterday, she said that in the midst of all the brouhaha surrounding this, she has revealed that she has received threats and veiled threats to the effect that if she fails to resign or voluntarily retire, she will be made to suffer some harm or the other. Why is this not tabled before a court so that she gets the needed protection she needs rather than make this a public affair?
Well, very good point.
And where is the evidence even? Yeah, go ahead.
So a very good point. And I think that she will probably put this before either the police or the court. But it's also important, like I said earlier, that the people of Ghana, for whose interest she serves, are made aware of every event. Because look, when somebody threatens you, you might not know when the person will carry that threat through. And so it is important that the people of Ghana are made aware of the things she is going through. And I believe that she's not just telling us. I believe that she's taking steps. If it's a threat of physical harm, she's made the effort of letting the police know this.
But if the Chief Justice is fighting over procedural breaches and she herself is following a path that is non-conventional or doesn't necessarily follow the rules of the game succinctly, where do we draw the line between who's right and who's wrong, and how do we even begin to bring some sanity to the judicial system?
So I'm wondering which part of the fight is against.
Well, coming to the public in the first place, making these allegations rather than going to the police, because you're saying that the processes, the way they're using or interpreting Article 146 is flawed, and you're also doing something that is contrary to what the Constitution stipulates, or the manner in which you can seek redress if you think you're being treated unfairly. That's two wrongs, right? Two wrongs. Go ahead.
This is the point. The Constitution doesn't say that the petitioner or the accused person cannot put her case before the public. Or the Constitution says that the hearing must be done in camera, and the hearing is being done in camera. But she feels that she needs to let the people of Ghana know what she is going through. That is different from the hearing. The hearing is being done in camera. As soon as if she's brought the petition to the petition process to the open. No, that's not what she's done. She is telling the people of Ghana that, look, this is your Chief Justice. This is what I am going through. My lawyer is being denied the right to represent me. Okay? I am facing these kinds of searches. And look, the point about our good Lord, she feels that it is psychologically traumatic for her. She needs to let the people of Ghana know. And look, before she came out yesterday, she had put this petition before the Supreme Court. She had put the petition to the members of the committee that, look, I am not comfortable here. And all commissions of inquiries have been done at the judicial service, have been done at the court. So why is this different? Why are you bringing me to this thing? She made that case to them, but they refused to hear it. So sometimes when you don't have the answers, you have to let your people know. She served the people of Ghana as the Chief Justice. And she said, look, people, this is what I'm going through. So I don't think that she's done anything procedurally wrong in this time.
Kojo, just excuse me one more second. I asked this question because, and correct me if I'm wrong, I understand that the processes, the inquiry is sub judice, right? Which means that it's under judicial consideration and prohibited from public discussion elsewhere. Is this correct or wrong?
Well, it's sub judice. But
So if it is sub judice...
When a matter is sub judice, the law is not that you cannot discuss it. That has never been the case. You always discuss cases that are being done or pending in court. What you don't discuss is you don't prejudice the outcome. And I don't think what she tried to do yesterday was to prejudice the outcome. She is not prejudicing the outcome. She's just making her case. And for me, that's the difference. You are able to discuss any matter which is subject to case, but you don't have to prejudice the outcome. And I don't think she did that yesterday.
All right, thank you for joining us. We want to get some thoughts and questions from the general public listening to us. If you can stay with us a few more minutes, we'll be happy to come to you for some of the response. The number, okay, so thank you so much, John Darko. I understand we can release you now. And John Darko is a member of parliament for Swami and also legal counsel for the NPP. We want to hear your thoughts on this very crucial matter. Join us. The phone number to call is on your screen, 0302 211 691. Kojo, you know what's interesting?
No.
It's the interpretation that John Darko just gave to what sub judice mean. I thought that this means that once it's under judicial consideration, nobody should be discussing. And he says he's not preempting the outcome. But yesterday, the Chief Justice disclosed how some members of the committee are treating it. It talks about the breaking the rules of disclosure, how a petition, an application was struck out by on the order of the Attorney General. These are matters that are related to the case that is being considered. And she's speaking up on these
One thing I've learned about this is that when it comes to the law, the lawyers, the people who know law, interpret it in different ways. So, I mean, it is for the court to decide that what you did is wrong or right. And so when it comes to these matters, I want to stay away and let the legal people battle.
All right,
it out.
so let's usher in our very first caller from Achim. New Achim Oda. All right, thank
they say
you.
New Achimota.
Oh, just the
Is that it? New Achimota.
Good morning, you're live. Has the Chief Justice courted any sympathy, you'd think, so far? What do you think?
Yeah, good morning.
Actually,
I wanted to comment on the last point that lawyer Jordan made. I'm not a lawyer, but you asked him whether the issue is sub judice and that they should not preempt results or whatever the outcome may be. But I think yesterday the Chief Justice did, because she did mention that it is possible the committee will go ahead with the issue and then the results will be that she's innocent. However, they can concoct a reason when one is not open to the public to say that she's actually guilty. So even lawyer John Darko is saying that she's not supposed to preempt or prejudice the outcome of the case. And I think the Chief Justice did that yesterday. Thank you.
Oh. Thank you.
Well,
the point we're making.
No, well, that's his interpretation anyway.
Yeah.
Somebody will also say, like John Darko said, she didn't preempt the outcome of the process. But yeah, like I say, when it comes to the law, everyone and how he or she look. The day we spoke to one Supreme Court former Supreme Court judge and a legal luminary, an older one, and how they both saw the law from a different perspective. I said, wow, let me stay where I am.
We have another caller from Yendi. Good morning. What are your thoughts?
Good morning, madam. How are you?
I'm fabulous. Share your thoughts with us.
Good morning, madam. How are you?
I'm fabulous.
Greetings to all of you.
Okay, go ahead.
Madam, Torkornoo have to go. There's nothing can save her. Look at what she has done for the past. For a judge to sit on case and tell us that passport is more than birth certificate in Ghana here, Massa, and people accepted that judgment of. Look at the case between Abandabin and how do you call it? Afenomaki. The day the Maki take that case to court, that day, no, they judge the case and bring it back that they should go on. And please, you this girl too, and how do you call it? Benjamin and Evans. I beg you people, NPP is gone. Whether you like it or not, NPP will never come back. If they come back or not today, you know what you people are doing.
All right. Thank you so much for calling and sharing your thoughts with us. We appreciate it. Let's usher in Derek from Tabora. Derek, good morning.
Unfortunately, I think we've lost Derek there. Well, you can also call us and join us with your point of view here on the AM show. We've been discussing the Chief Justice and her presser yesterday. We're asking what you do make of that presser yesterday. Well, so you can join us. The number to call is on the screen. Call us and let's have your point or your thought on the presser by the Chief Justice yesterday. We've also spoken to lawyer John Darko. He's given us his understanding of the whole issues. Dr. John Osekapon has also joined us with his thought on the presser there. What do you make of that? Call us and let's hear from you.
See, there are some people who are downplaying the emotional trauma that the Chief Justice spoke about, but I think nobody can actually explain how you feel about the situation.
Yeah.
You know? And so we cannot take it out of context and say she's playing into the politics of what we're seeing. And,
especially when she brings up the issue that same place was where her benefactor, I mean, the person who was taking care of her was, murdered, huh? I mean, you cannot take that away from her. That you bring that memory to her. And she said, at the time she was abducted, I was living with him.
So it's very raw,
yeah.
but that also raises the question of, should we be hearing this from her in the public now, or is this something that she could have gone to any of the judges or the committee members and say, listen, you cannot try me, you cannot hear this case behind the high walls of,
We'll come back to this after we return from Kumasi.
Okay.
Let's go to Kumasi.
Let's go to Kumasi. We have a caller. Share your thoughts with us. Good morning. Kindly speak up for us.
Yeah, good morning. I'm Eric calling from Kumasi.
Okay, go ahead.
Yeah.
We can hear you now. Okay, I don't think he's still online with us. If he is, he's not speaking. But do call us, 0302 211 691. Kujo, I'm dying to hear your thoughts on the matter.
On that.
Yeah, the last point I raised.
Okay, so we don't know. She didn't tell us whether she raised it with them.
Yeah.
But once she decided to come out to the public to let us in on what's happening, I didn't even know that where the place was called Edu. I knew that it was close to the. I mean, first it was at the Osu Castle. She had issues with it. Now she's revealing that this is Edu Lodge where her uncle suffered this kind of treatment. Well, whether or not we were right to hear, I'm glad that it came out. But as to how it affected the process, I've heard legal luminaries who say that she was even not supposed to have come out in the first place. Maybe that would be the score, but.
Robert is online with us from Edumase. Robert, what do you make of the current situation with the Chief Justice?
And to my view, for how long has she realized that there are some flaws with this process of removing the CJ? You see, if you are in an institution and you see that there's something wrong somewhere, you don't wait until it hits you before you start to try to avenge yourself. So now, what is at hand and on the table is what we get. So that's situation fine, and that's what I have to say.
Thank you. I think, Brace, that's featured in your question earlier about, being a Chief Justice for over so many decades. You should have known at some point that the Article 146 was flawed. We have Hamza. I think he's a regular caller from Ashaiman. Hamza, good morning.
Yes, good morning.
What's on your mind?
Anyway, good morning. I'm saying that in the recent Supreme Court ruling, we heard that you cannot force anybody to testify. So I'm just surprised hearing the Chief Justice mentioning that the petitioners are not meant to testify. I think in just 2020, and then she was on the panel, just 2020, she said that the election petition, they ruled that a petitioner or you can't force anybody to testify.
Exactly.
I think that is the ruling. If my memory says
You're right. You're right. Yes.
Yes. So why is she crying in the media? For saying her uncle was murdered in the lodge. It's a total blackmail. Please, you should face the law and then stop all this. She just came to the media to criticize what is going on over there. That is not right. The Chief Justice must not do this. The Chief Justice position is not her best right. So she should go through the process, and then if she's exonerated, that's it. Thank you for doing a good work for Madagascar.
Thank you very much. So on that score, someone referenced me to some cases where that particular, ruling was given that you cannot force, a party to testify, really. But I guess that as the lawyers do in court, even though you know that this may not be right, but you could force your way. Someone come by into you.
20% of what it's written and 80% exactly. We have someone calling us from Ablekuma. Good morning. What's on your mind?
Good morning.
We can hear you loud and clear, sir. Go ahead.
Yeah. I'm asking that what the Chief Justice, let's put it former Chief Justice, she's doing now. So is it possible they can bring her back? Is it possible? And then if possible, so when they bring her back, how will she feel? Like staying with the others, everybody is seeing that she did wrong. But only her, she's seeing that she didn't do anything wrong. So can her come back to her office? And then if she come back, how she feel? Thank you.
Well, I think coming back to her office, she doesn't have an issue with her fellow benchers. No. So, as for coming back, if the committee sees her to have no question to answer, and they throw away this petition as John Darko was calling for, of course, she comes back to her office as a CJ.
That's the whole point of this process, anyway,
yes.
to determine whether there's been some egregious crime committed which warrants her to be completely removed. Because as we speak, she's still just suspended to allow the processes to go on smoothly without interference. Unfortunately, this has come back into the media domain, so we will talk about it, and that's why we're asking you to call us. I think we have time for a few more calls. 0302-211-691 is the number to call. And Kojo, I mean, did you listen to the entire presser yesterday? I found out that the Chief Justice had a calmer tone compared to the other pressers she's had. I listened to her leading justice press conference and watched her during the LGBTQ debates and hearings. I think she was very up on energy in those instances. But yesterday there was a calmer tone to it, and I think this is all taking a toll on her. We are not saying it enough. Well, she's suspended for the very first time in our history. She's the first Chief Justice to go through this.
I'll come back to that. Okay. But let's bring in Angelo from Domipela too.
All right. Angelo, share your thoughts with us.
Good morning, sweetie.
Hi, morning.
Okay. The Chief Justice, I think, is really going out of her lane to exhibit certain tendencies that we, the laymen who are not lawyers, would not even attempt to do. Because in any instance at all, if anyone appears in court and he decides to now come out to make the public know exactly what is transpiring within the case, you could be cited for contempt and all that. I have observed it over a certain period of time. I remember when she had to start over a case involving Tide of Story. There were certain objections that Tide of Story raised, and there was a banter between herself and Tide of Story. At the end of the debate on that issue with Tide of Story, she just looked him right in the face, a senior attorney, and told him that his argument was a total waste of time of the court, and that he shouldn't have even brought that up. And I was surprised because for a whole Chief Justice to look in the face of a lawyer, a renowned lawyer like Tide of Story, to tell him that he was actually exhibiting matters that was a waste of time to the court, I was really disappointed. So this lady's actions and inactions have been so much that I think the Ghanaian public have had enough of it. She should really, leave the office and let somebody better who is neutral enough to handle affairs of the Supreme Court, because she's done more than she can do now. And let us, ask her to sit aside and let the process continue. Thank you very much.
Thank you for calling.